First off, I'm Kevin Powers, the founder and director of cybersecurity graduate programs at Boston College, where I'm also a professor of the practice, where I teach in the Carroll School of Management and over at Boston College Law School. I'm also, as part of my higher ed work, I'm a research affiliate over at MIT Sloan in their cybersecurity programs. And I also am teaching a new program in executive education over at MIT Sloan. It's called Cybersecurity Governance for Boards of Directors, and we're launching that in this upcoming November. I've been an attorney for over 20 plus years, and I've been really an analyst, an attorney, a business person in big firms and in the government, focusing on cybersecurity, data privacy, business litigation, and military and law enforcement for over 25 years. So I'm pretty old, I guess, now. With that, I was unsure of the format here. I thought it was going to be more of a Q&A. I guess it's not, but I think we have the portal here. So what we could do here, if you want to use the chat, you can jump in and we can go through questions. So the title of today's discussion, which will be very informal, is new cybersecurity regulations, the SEC and beyond. I think what we'll focus on here with our limited time is really the new proposed regulations coming from the Securities and Exchange Commission. I'll talk a bit about those right now. So the Securities and Exchange Commission, sometime in March, they came out with two sets of proposed rules. There's similar, almost identical, focusing on cybersecurity. One set was for wealth managers. So when you think of wealth managers, you think of Morgan Stanley, John Hancock, Manulife, big wealth managers, okay? And also other institutions that handle wealth. You know, they handle your 401k plans like Fidelity. It also applies, they came out with another set of rules, all similar in scope. I guess I can request you in the room if someone wants to join. I'll keep my eyes open for that. This is a little different than Zoom, so I have to check out the different gadgets. So similar in March, the SEC came out with these new proposed rules focusing on cybersecurity, cyber risk for publicly traded companies. So any company or organization that is public and subject to the SEC's jurisdiction, there's these new proposed rules, and I'll walk you through the key 4 elements of these rules. And what I can do too is take questions here, but give you some my thoughts of where this is going, what it means to really publicly traded organizations. But for you, if you're a CISO or any other cyber practice, how is this going to impact you, whether good or bad? So first off, 4 parts to this proposed rules. First being reporting requirements. So they came out with a new definition of what an incident is. And it's not, you would hope for consistency across the government, but you can keep hoping for that because it doesn't seem to be the case here. When the NIST framework came out in 2014, via the government, the National Institute of Standards and Technology, one of the keys there was to have plain language, the same language throughout everyone. When we're talking about an incident, it means the same thing, whether you're in the United States, you're in Europe, you're in Asia, or wherever you are, or whatever agency you're dealing with, you wanted to have the same terminology because that's what cybersecurity is. Well, not the case here with the SEC. They came up with a different definition of incident. This is the proposed rule, and a lot of the feedback came back and said, get this consistent. But one of the key terminologies for this rule is materiality. And that's a term of art when you're thinking of the SEC. So it has to be a material incident. What do they mean by a material incident? Materiality deals with, it's material if the risk involved or any type of breach involved would materially impact my decision as an investor or a shareholder to make decisions to keep my money with the company or even invest in the company. So materiality deals with me as a shareholder or an individual investor, whether I want to know this information, because if I hear this information, that might be material to my decision to invest in the company. So that's what materiality is. Then they throw on incident, which means any unauthorized access to your systems or data that you have, whether it's personally identifiable information or intellectual property or any type of data. So that's one. But in reporting or disclosing the information, you have 4 days to do it. So if there is a data breach and you make a determination, so this is up at the board level, this is at the C-suite, the CEO, you make a determination, this is a material incident, you have 4 days from that time to report it, and you would disclose it through an 8K. So this would go out to the public that, hey, we had a material, what we think is a material incident that we wanted to get out to you so you can make proper decisions of whether to keep your money with the company or invest in a company, right? So that's a short period of time because it's not only determining is it material. So there's a lot going on there. There's been a lot of pushback on that, asking for more time to do so. Another aspect of that too is that it seems to be continuing. So if you made your disclosure 4 days, you make a determination, it's within 4 days from the time you determine it's a material incident, and then something else happens along the way, you have to keep updating with whether it's 8Ks or in your 10Q or your 10K, your yearly filings. So there's a question, is this a continuing, just keep giving updates? And that seems to be the case based on the proposed rule. So that's one. So there's the time constraints in there and then the extra of materiality. Two, this is at the board level. And we talked about this earlier today, and you probably heard this throughout today's conference, and you'll hear it in the coming days. That cybersecurity is really becoming a core function of a business, and it's taking place way up in the boardroom and at the C-suite. And with that, what the SEC wants, and these are all disclosures, okay? So what they are is required disclosures, proposed rules. That doesn't mean you're binding that you have to. The only thing you have to do is report. That's the 4 day. The next piece, what we're going over, you're not held to do it. It's not prescriptive. However, if you don't, you're going to be more likely in trouble if something does happen. And more so, who's going to invest in a company that does have all these protocols in place that the SEC says they want you to disclose each year? And let me walk you through that one, what I mean. So with board of directors, they want you to, one, demonstrate the expertise of the board of directors with regards to cybersecurity. If you have a cybersecurity expert on the board, which they're asking you can have one person be an expert, but if you do, you have to show that person's CV, how they were educated, how they worked in cybersecurity, what's that background, and it can't be just a technical background. They want to have someone who has a whole holistic idea, an enterprise approach to cybersecurity and cyber risk. Also, they want to know how the board is trained. How did they get that expertise? And do you have committees set up? How do you discuss cybersecurity at the board level? Is it through the audit committee? Is it through the finance committee? Is it through the risk committee? Or do you have a cybersecurity committee set up? Who's on that committee and how is that information shared? So they're really going to the board and saying, what do you know about cybersecurity and how do you know about this? You can't just say, hey, we have trainings on cybersecurity. They want to see what those trainings are and how well versed the board is in cybersecurity and cyber risk. So that's one. Two, with regard to the board, this continues on, they want to know what the board's involvement is in the business cyber risk strategy. So the overall enterprise risk management program and cybersecurity and data privacy program, how is the board of directors involved? Who do they talk to about this? How are they briefed on all of this information? How do they approve funding for cybersecurity? What information are they getting and what knowledge do they have on that? And that ties into the next piece, which is management's role. Okay, so now you're talking about the senior executives, you're talking about the CEO, the CFO, and others. They have to demonstrate and say what their role is in building out a cybersecurity program. How do they work with the CISO? How do they work with the IT team? How do they work with legal? How do they work across the board? What is their program and what is their involvement? How often do they talk to the CISO? What is the CISO telling them? Okay, so they're really putting the pressure on to demonstrate through disclosures, this is how the senior staff, the board of directors is informed, understands, and works and builds out cybersecurity programs to have that their business work successfully. All right. The next piece of all of this is, what is your cybersecurity program? Okay, so they want to see what your program actually is. And what they want you to disclose is how your program aligns with what they prescribe. And what they prescribe is similar to what you see in the New York Department of Financial Services Part 500. They want you to disclose, do you have a cybersecurity program? What type of policies do you have in place? List those policies. Do you have an incident response plan? How is that tied in with your business continuity plan? Do you have penetration testing? Do you have vulnerability management? How do you manage that? Do you have encryption, end-to-end encryption? Do you have encryption at rest, right? So you have to go through each one of these things. Do you have multi-factor authentication? Do you have a cybersecurity culture? Do you train your employees? How do you train your employees? Do you have audits? Who does your auditing? Do you have internal audits? Do you have external audits? They go through each one of these things. And then here's the buzzwords that they have in here. It's your cybersecurity program built in a way that identifies, detects, protects, responds, recovers. Okay. What they're talking about there is the codification of NIST. And that's how they want to have things aligned. So really, when you're looking at the SEC proposed rules, what they are doing is they're focusing on the board, the expertise, there's the incident reporting, the highlights of the board. How are they involved in this? Not only with their expertise, how are they building out the program? You have the management piece, and then the prescription of how you build out the whole program. So that's the SEC in their rules. And when you look beyond this, it's all consistent, right? It all starts back with New York and the Department of Financial Services regulations in 2018 when they came out with that Part 500. And what you're seeing is the SEC with their proposed rules really mimicking them in many ways. And then you look at what just came out with the FTC with their new safeguard updates. They're identical in scope. And what all of them are doing is putting the pressure on the top to bring cybersecurity down and across the enterprise. So those are the proposed rules that are out there. I'm not sure if anyone has any questions or concerns or how I can address it further for you. But my thoughts are, there's going to be a huge impact on the business, which is going to push down on chief information security officers and the security teams. And I think it's what you've been asking for. It's to get a seat at the table, to get up to the C-suite, to get in front of the board and do it in a regular basis. So what you're going to see more often now, if you're a chief information security officer, you're going to be briefing at every quarterly meeting. Okay. If you're not on the audit committee, you'll be on the audit committee, or you'll be on this new cybersecurity committee or emerging technology committee. That's what they're talking about. In fact, there has been a research by Gartner that talked about right now, currently, I think it was 2021, 10% of boards, publicly traded boards, have a cybersecurity committee focused just on this. And what they're projecting by 2025 is that there'll be 40% of companies will have a cybersecurity committee. I think it's going to be bigger than that because now with the proposed rules and the other requirements. So prepare as a CISO to have a lot of activity from above coming to you and asking lots of questions. Hey, do you have an incident response plan? Great. What is that incident response plan? Can we take a look at it? What's our role in this? You're going to have more and more questions because they're going to be required to do so. And it's important that they do this. So everything you've been asking where you wanted more insights and you wanted to be part of the business and you wanted them to take you seriously, they've always taken you seriously. But I guess more looking at you as a key business function, that you're key to their business surviving, you're going to see that and you're going to have more activity. So prepare accordingly. I think your role is going to expand and you're going to have a lot of tough questions because it's all going to fall on you. And they're going to expect you to give them the answers, not that they want the truthful answers of this is where we are, here's our roadmap, and this is what we need from you to succeed. So with that, I don't want to turn this into a whole law lecture. Does anyone have any questions or anything here in the chat? Okay, great. Please, what is the regulation I must follow in UK and you for informing the board? Sorry, Dr. Fabio, I don't have those right in front of me right now to point you to any UK or EU regulation at this time. I wish I did, I just don't. Let's see, FDIC, FRB, OOC set a 36-hour rule. Do you know if it's similar to the SEC regulation except for the reporting time frame? That would be dealing with a data breach, an incident impacting the systems or the data that they have. The difference here is that the material component of it. Okay, so materiality changes it. So you could actually have, under the SEC, if you had an incident so defined, you would not have to disclose it unless it's material, meaning that it would impact me as an investor or someone who's already invested in the company, making my decision of whether I'm going to keep my money with the company or not. So that's a little different there. Yeah, sorry about that, Fabio. I wish I had that answer for the EU. I could point you to what the regulation, please wasn't the EU for informing the board. Well, I would say any business that's out there, you would want to keep your board apprised. So whether you're in the EU or wherever you are, you need to make sure that the CISO is not hiding information from the board of directors. The CEO is not, because they can't conduct and oversee your mission of a company. So there's going to be a regulation out there. So perfect, sure. Any other questions out there? Excellent. All right then. I guess you guys are free to go. If you have any more questions and concerns, you can email Ethan and he'll get them to me, and I'll respond accordingly.